Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again, please.
Anitra Lynn Coomer.
All right, Ms. Coomer, it is this court's understanding that you are going to be pleading guilty to the charge of assault and or assault and battery. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
I do.
In understanding that, do you still wish to plead guilty?
I do.
And to that charge, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
Ms. Apple went through an advice of rights form with you. Is that correct?
She did.
And you understand that all of those rights she went through are rights that you'll be waiving as a result of this plea?
Correct.
Did you have any question regarding any of those rights?
No, sir.
You understand you're giving up your right to appeal of right?
Correct.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
I am.
Of your own free will?
I am.
And also because you believe that you're guilty of this offense?
I do.
August 5th, 2024, at the location of the Huron Valley Correctional Facility in Pittsfield Township, Washtenaw County, state of Michigan. What did you do involving a Bridget Gifford that makes you think that you're guilty of this offense?
Your Honor, may I voir dire?
Yes.
Thank you. Ms. Coomer, on that date and time that the judge stated, did you make contact with Ms. Gifford?
I did.
Okay, and you, by pulling her hair?
I did.
Okay, and you did not have permission to do that?
I did not, no.
And that act upon her was not in self-defense?
Correct.
Defense is satisfied.
All right. And ma'am, you understand that if you commit misconduct as defined by the Michigan court rules between the time I accept your plea and the date of your sentencing, that any agreement, although there isn't any, regarding sentencing or any evaluation of your case, the court would not be bound by, and also that you could not use that as a basis to withdraw your plea, or would not be permitted to withdraw your plea. You understand that?
I understand. Yes, sir. Yes, sir.
Counsel, are there any other promises, threats, or other inducements which you believe or you know of that have led to this plea?
No, Judge.
All right. Have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Normally, I can't do it on this case because it's victim's rights case. So a pre-sentence investigation and report is ordered. Sentencing in this matter will be
August 13th at 9 a.m.
Can't do August 13th because I need 2 weeks for a video writ. It's going to be the
August 27th at noon.
August 27th, 2025, 12 noon. And that's before me. Bond will continue. All
Thank you,
right.
Judge.
All right. Thank you, ma'am.
Thank you. Thank you.
Court does call the case of the people versus Jennifer Lindsay.
Sorry, Lord Jackie, Assistant Public Defender with and on behalf of Ms. Lindsay. Ms. Lindsay, can you state your name for the court?
Jennifer K. Lindsay.
You're requesting an adjournment.
Yes, Your Honor, for some additional discovery.
Probable cause conference without objection, August 19th, 2025, 9 a.m.
Thank you.
Bond will continue. Thank you, Ms. Lindsay.
Thank you. Thank you.
Court calls case people versus Justin Duffany.
Victoria Burton Harris, Assistant Prosecutor of Huron County People.
Kyle Burrell on behalf of Mr. Duffany, who's approaching the podium as we speak. Mr. Duffany, please introduce yourself to the court.
Justin Duffany.
Thank you, Judge. Today's the date and time set for probable cause conference. I was just appointed on this matter yesterday afternoon, so we are asking for a brief adjournment for for discovery and for plea negotiations. At this time, there's also a bond violation or a.
There is.
Yes, Judge. So I spoke to Mr. Duffany. He went to community corrections yesterday at 4:20 p.m., but he did not have the money to test, so he was unable to. We did discuss today. He's going to go immediately to community corrections after this. I do have an email from community corrections to confirm that he was there.
Is he going to test clean?
I believe so, Judge. Yes. He's on what?
Are you going to test clean?
I'm on Suboxone. I'm prescribed Suboxone.
You're prescribed it? I'll pass it. He needs to get over there and test and then come back.
So thank you, Judge.
I'm not doing it anymore. Takes too long. Just go on. Court calls the case, People versus Jonathan Faith.
Good afternoon, Your Honor. Bovis with and on behalf of Mr. Faith, Jonathan Faith, introduce yourself to the court.
Mr. Faith, can you state your name, please?
You gotta unmute.
Jonathan Faith.
Judge, this is first PCC. I just got the discovery. I subbed in this week. I'm asking for a brief adjournment as well.
As soon as the prosecutor puts her appearance on, we'll be happy to proceed.
I was trying to wait.
I know. You were going to start, but he just kept talking. Go ahead.
Sorry, Judge.
Victoria Burton here, Chief Assistant Prosecutor, again appearing on behalf of the people.
Do you have any objection to the adjournment?
I do not, Your Honor.
Probable cause conference in this matter will be adjourned August 19, 2025, 9 a.m. Bond continued.
Thank you, Judge. Good seeing you.
Thank you.
Bye.
Court calls case People versus Andrew Gendy.
Good afternoon, Your Honor. Andrew Fanta on behalf of and with Mr. Gendy.
Good afternoon, Mr. Fanta. Long time no see. Hope you're doing well, sir.
Thank you, Judge, and you as well. And Your Honor, I just received discovery, and I would like to get this matter adjourned. Would that be on a Tuesday or a Thursday, Judge?
Well, this month we have both. I have Tuesday the 19th. It would normally be adjourned to a Thursday. So I have the 14th, the 19th, or the 28th.
I can't do, could we adjourn it to Thursday, September 4th?
Wow.
I know I'm going to be out of the country and I'm going to be in northern Canada, and I don't know whether I will have any internet connection.
I hear they cut it off for all Americans. No, I'm kidding. I don't know what happened. Didn't used to happen that way. All right. So wrong. Well, give me this. The September 4th. Any objection to the September 4th date? All right. I will do that for you, Mr. Fanta. We'll adjourn this to September 4th, 2025, 9 a.m., or as your invite indicates, bond will continue. Right?
Thank you so much, Your Honor, and
thank you. All right. Safe travels to you.
Thank you, sir. Bye-bye.
Bye-bye. Court calls the case of the People versus Naia Lee.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Ms. Lee. She's coming up. Ms. Lee, could you please state your name for the court?
Naya Lee.
Others? All right. Anyway.
Your Honor, we're asking for an adjournment to review discovery. A bit past 2 weeks if possible. We're waiting on some things that might take a while to be produced. So,
without objection, August 19, 2025, 9 a.m. Bond will continue. Thank you, sir. Court calls case of the People versus Jaquan Holland.
Stephanie Cannon.
No, we'll wait for you to have the conversation. Are you talking about his shorts? Lack of pants?
Yes, Your Honor.
You are?
Yes, I was.
What'd you tell him?
I told him that we have to dress appropriately for court from here on out, not to wear shorts.
Did he
I know.
understand you?
He understands, Your Honor. He's apologetic. As soon as he leaves here, he's going to work, but he'll make sure he's dressed appropriate next time.
All right, what are we doing in this case?
Your Honor, I'm just asking for a 2-week adjournment on, or actually, you changed your mind. You said you want to go to exam, correct?
Yes.
Your Honor, my apologies. When we spoke yesterday, we were adjourning. Today, we are going to go ahead and set up for a preliminary exam. I'm going about the rules.
That was dramatic.
I'm sorry, Your Honor. Also, Your Honor, can I address bond when you're ready? I'm sorry.
He's out.
He is.
Oh,
That is accurate, Your Honor.
okay.
He is untethered, though. We would like to ask for the tether to be removed. This case it
Set the
happened.
preliminary exam first.
We can. We absolutely
Thank you.
can.
Discovery is complete.
Yes, Your Honor.
Would people have their witnesses available to 12? Preliminary examination in person, August 12th, 2025, 9 a.m. That is before Judge, before Judge Valvo. Yes, Esteban.
Esteban, Your Honor, we'd ask for the tether be removed in this case. This case actually happened over a year ago, more than a year ago. He's had no contact with the complaining witness. He's not going to have contact with the complaining witness. He comes to court. He's in front of Judge Hammoud. He's never missed a court date, so that's not going to be an issue. He is not a threat to her or to the community, Your Honor. We are asking for the tether to be removed.
Response.
People that are asked for the tether stay in place. I did do the arraignment on this. We are asking for that tether to stay in place for the safety of the complaining witness. The only restriction that this tether has, based on my notes in his arraignment, is he's not allowed to go to that particular judge. So I don't see how that inhibits him in any way.
Your Honor, she doesn't even live in Michigan anymore.
Well, I don't know that. I mean, I know you're telling me that.
I understand, Your
I
Honor.
don't. The motion to modify bond at this time is denied. Certainly, you can take it up after preliminary examination with Judge Valvo on the.
Is it Valvo or Fresh Hour, Your Honor?
What did I tell you? You didn't write down what I told you. Did you?
I wrote Fresh Shower, but you just said Valvo, so I want to make sure.
Which judge did you give me? Valvo, right? That's what you said, and then I said it.
And Your Honor,
Oh, you said Valvo, I said Valvo, she wrote Fresh Hour.
I'm getting old. It's my hearing. It's going.
So it's Valvo. All right. Court calls the case, People versus Antoine Coleman.
Good afternoon, Your Honor. Kerma Dadush on behalf of Mr. Coleman. Mr. Coleman, can you unmute and state your name for the record and remove your hat, please? Thank you. You have to unmute first.
Alan, can you get me that last one?
Now I have it.
Yes, we can hear you now. Can you state your name for the record?
Antoine Coleman.
All right. I have before me, hold on a second. Is it the one that I have before me a plea form that indicates that the defendant will be pleading guilty to an added count 3 of operating while intoxicated, second offense, the 1-year offense. Upon his successful plea to that charge, counts 1 and 2 would be 1 and 2 would be dismissed. That is the court's full understanding of the agreement on this agreement form. I do have in here a memorandum of understanding regarding transfer of jurisdiction. Is part of the plea.
No, it was not contingent on anything else at this point. It was just contingent on the screening and referral process that's done. So it's just as is.
Very good. Is that your understanding?
Yes, Your Honor.
All right. Sir, if you could please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
State your name again for the record, please, sir.
Antoine Coleman.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court cost. The court could order any community service or rehabilitative services the court deems necessary. The court could also order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
I do.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and that you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
I plead guilty, sir.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5 of that form. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you in any way?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you're guilty of this offense?
Yes, sir.
August 24, 2024, at the location of 528 East Clark Road in Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, sir.
You recall what you had and how much?
I had approximately 3 shots and probably maybe 3 to 4 beers.
All right. Were you stopped by the police or was there an accident?
No, sir. I was sitting at the gas pump.
Okay. And the police arrived?
Yes, sir.
All right. And somebody had called?
Yes, sir.
Are you disputing the right of the police to stop and or detain you in this instance?
No, sir.
All right. Were you ultimately arrested?
Yes, sir.
All right. Were you taken to the police station or the hospital?
The hospital.
All right. Was there a blood draw?
Yes, sir.
And what were your blood test results?
Pretty high, sir. I don't know the exact number.
If counsel is willing to stipulate, Your Honor, have blood results of 0.164.
We stipulate to that, Your Honor.
All right. And so you don't have any reason to dispute those blood test results, do you?
No, sir.
All right. And had you previously been convicted of operating while intoxicated on or about September 7th, 2021 in the Third Circuit Court and or of operating while intoxicated on or about October 16th, 2017 in the Third Circuit Court and or operating while intoxicated on or about August 11th, 2017 in the Third Circuit Court?
Yes, sir.
All right. Sir, you understand that between the time of my taking your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that any evaluation or sentencing by the judge would no longer apply and the judge would not be bound by that. You understand
Yes,
that?
sir.
Any agreement? Okay. You also understand that you would not be entitled to withdraw your plea.
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No to the people.
No, Your Honor.
All right, and has the court complied with the court ruling? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is still satisfied.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B District Court. Sentencing in this matter will be
September 4th at 10 a.m. with Judge Washington.
September 4th, 2025, 10 a.m. before Judge Washington. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you.
Court calls the case, People versus Monica Collins.
Andrew Banner.
Hello.
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 Assistant Public Defender Natalie Pate with it on behalf of Ms. Collins. Ms. Collins, can you please state your name for the record?
Monica Collins.
Thank you, Your Honor. I'm respectfully requesting an adjournment. The phone number I did have for Ms. Collins was her friend, who I believe did help her get to the Zoom today. However, I am needing to have a conversation directly with my client. I'd ask for an adjournment for that to happen and also request that Ms. Collins call the public defender's office to update with the best phone number if possible.
Probable cause conference without objections adjourned to August 14, 2025, 9 a.m. Bond will continue. Ma'am, do you have the number to the public defender's office?
No, can I actually get it right now?
Yes, I'll be more than happy to give it to you. You got something to write it down with?
I'm gonna write it in my notes. I'm actually on my notes right now.
Pardon?
I'm gonna write it in my notes.
I believe on her phone, Your Honor.
I know, I'm not that old. Thank you. Number is area code 734 222 6970.
6970. Thank you.
You're welcome.
Thank you, Ms. Collins. Thank you, Your Honor.
Thank you. Yeah.
For the record, I'm really bad at technology. I'm probably worse than you.
Oh, I know you're worse than me.
Yeah.
You're in my court. All right. Court calls the case, People versus Christopher Cummings.
Abigail Nice-Swanger requesting permission to practice pursuant to MCR 8.120 under the supervision of APAG Kennedy.
I thought we got all that over with this morning. No, I saw you. You came in late. Yes, you did. I saw you walk across right there. I did. And I said, hello. Nice of you to show up. Wow. All right.
She made that with the utmost respect.
Is it? Yeah, she still got that permission to practice hanging in the balance. Permission to practice is granted.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. Cummings. Mr. Cummings, could you just say your full name?
Christopher Cummings.
All right. And I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of assault and or assault battery. On his successful plea to that charge, count 1 would be dismissed. Defendant also agrees that there will be no deferred sentence agreement. There will be alcohol counseling, sex offender assessment, and probation, no contact with victim, and alcohol assessment. The prosecutor and defendant agreed to a sentence agreement of probation with conditions, no deferred sentence agreement. That's the court's full understanding of the agreement between the parties.
Yes, Your Honor. Sorry.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name.
Christopher Cummings.
All right, sir, it is this court's understanding you're going to plead guilty to the charge of assault and or assault and battery. That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. Understanding all of that, still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty that you will not have a trial of any kind?
Yes.
All right. You signed an advice of rights form. Is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On the date of January 5th, 2024, at the location of 3344 Grove Road, Ypsilanti Township, Washtenaw County, State of Michigan, what did you do with reference to a Bethany Conde that makes you think that you're guilty of this offense?
Gave somebody a hug. And I guess they didn't want me to. Yes. He said, what did I do?
Well, you
Yeah.
just told that to me.
Yes.
Did you want an additional voir dire? I'm not.
Yeah, so you made physical contact with her.
Yes.
She did not want you to do that,
Yes.
and she did not give you permission to make contact with her prior to making contact with her.
Correct.
All right. Sir, you understand that if I accept your plea between today's date and the time of sentencing, that if you commit misconduct as defined under the Michigan court rules, number one, you could not withdraw your plea, and any sentence agreement or evaluation, the court would no longer be bound by. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
All right. Have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied, Your Honor.
Your Honor, we would just ask that the victim's name be placed on the record.
Pardon?
We would just ask that the victim's name be placed on the record.
Good.
Oh, okay.
I know. Plead guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
September 4th at 10 a.m.
September 4th, 2025, 10 a.m. That is before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Here's the.
Hey, you were doing just, well, why did Kennedy even get up and get in your ear?
Well, I wanted to make sure that I knew what I was doing, Your Honor.
That what?
That I knew what I was doing, Your Honor.
You were just fine, because if you didn't know it, I would have called you out. I don't know why he got it.
We appreciate
He was just, no, he was interfering. Shouldn't have been. Court calls the case, People versus Parker Davis.
Assistant Public Defender Jay Bellinger on behalf of Mr. Davis, who approaches. Mr. Davis, can you please state your name for the record?
Parker Bradley Davis.
Your Honor, we did provide an earlier adjournment request. However, we did provide today a waiver form.
So you don't want it adjourned?
We do not. That is a little dramatic.
It's me today. All right. Sir, you are waiving your right to preliminary examination?
Yes, sir. Yes, Your Honor.
All right. You understand the preliminary examination is a proceeding where people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, Your Honor.
You understand that you'll not have a hearing in either one of your cases and you'll proceed to circuit court for further resolution?
Yes, Your Honor.
All right. People also waive the right?
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of information, waive formal reading, and stand mute at this time.
Defendant every way form of reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
September 23rd at 1:30 with Judge Humphrey.
September 23rd, 2025, 1:30, Judge Humphrey.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Bond. Pardon?
Sorry. You said a single count.
Yeah, single count in each case.
That's where I got confused with it.
That's where you got confused?
And then I.
What did that mean to you?
I thought it meant one count.
There's an issue over here now on this side.
All right.
No, it's okay, Ms. Douglas. I got you. Bond,
Thank you.
We'll continue. Thank you. Court calls the case, People versus Bruce Dinkins.
And here, Rachel, and Debbie for the people.
Cameron Dodge on behalf of Mr. Dinkins. Can you state your name for the record, please?
Bruce Dinkins.
My first client wearing shorts.
Is it?
It is.
Feels special?
It's a special moment right now. Your Honor, he won't appear in front of you before, but I'll make sure that whoever he appears in front of next, he is not wearing
It will
shorts.
be me,
Okay,
and
then,
I have a great memory.
okay. He will make sure not to wear shorts.
I sure will.
I have before me a plea form that indicates that the defendant has been pleaded guilty to the charge of larceny by conversion, 200 to 1,000, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the.
John.
May I have him sworn?
Right hand. You solemnly sworn to affirm the testimony you about to give will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
State your name.
Bruce Dinkins.
Sir, it is this court's understanding that you're going to plead guilty to the charge of larceny by conversion, 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would be the maximum fine. You understand that?
Yes.
And understanding that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay.
You understand that?
Yes.
You understand you're giving up your right to appeal of right? Is that a yes?
Yes.
Are you on probation or parole?
Probation.
Okay, were you on probation at the time of this offense?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
January 26, 2023, at the location of 2201 Hogback Road in Pittsfield Township, Washtenaw County, State of Michigan. What did you do that makes you think that you're guilty?
I misused by not charging my tether.
Permission to voir dire, Your Honor.
Please.
All right. The tether was given to you to use for a lawful purpose of testing your levels, correct?
Yes.
Okay, but and the value of the tether was $200 or more.
Yes.
Okay, and instead of using the tether in the manner that you were supposed to, you failed to do so by failing to charge it, correct?
Yes.
Could the people want to hear a bit further, Your Honor?
Somebody better.
Mr. Dinkins, while you had that tether and you were being supervised by the courts, did you at some point abscond from supervision, as in not show up to have anyone look at your tether?
Yes.
Okay, so did you essentially fail to return that tether to the people who gave it to you?
I returned it.
He returned it eventually.
Okay, was there a long period of time that happened when you kept that tether and didn't return it?
No.
Was there a period of when you weren't using it in the way you were supposed to be using it? Did you return it immediately, or did you wait a period of time before returning it back to probation?
I returned it immediately. Oh no, I returned it.
Tell me you work in law without telling me you work in law. How do I get to Zoom? This is peak remote court energy.
They asked for it back immediately.
No.
No, I'm going to pass the matter. You can have a
Thank you,
more
Your Honor.
detailed conversation with your client.
Thank you, Your Honor.
Thank you. Court calls the case, Buell versus London Daughters.
Good afternoon, Your Honor. Victoria Burke Harris, Chief Assistant Prosecutor, here on behalf of the people. That's my esteemed the council makes her way to the podium.
Ultimately.
Assistant Public Defender Chinazi Carey Akinruli, Your Honor, on behalf of Mr. London Dottery. Mr. Dottery, state your name for the record, please.
London Dottery.
I have before me a plea form. Plea form indicates that the defendant, well, he has two cases.
That is correct, Your Honor.
Your Honor, people are moving to dismiss, case 22FB 1318 as a part of the global resolution, with him pleading guilty under 1651. The nominee is getting his way to your staff.
Okay, so what I'm going to do is I'm going to add to the form that they're going to dismiss 22 FB 1318. All right. So form indicates that he's going to plead guilty to the charge of improper possession of a firearm in or upon a motor vehicle, the 90-day offense, and involving mandatory forfeiture of the weapon or device. Upon a successful plea to that charge, count 1 in that case, which is the case ending in 1651, as well as 22 FB 1318 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor. And I apologize for not blending that together.
No, it was Ms. Akinruli's fault, don't worry. May I have him sworn?
Right here. Testimony about to give be the truth, the whole truth, and nothing but the truth, so. State your name.
London Dottery.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of improper possession of a firearm in or upon a motor vehicle. That's a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs, and mandatory forfeiture of the weapon or device. You understand that, sir?
Yes, sir.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and that you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yes, sir.
All right. And understanding all of that, still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of rights.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
February 8, 2022, at the location of La Forge near Warburn in Ypsilanti City, Washtenaw County, state of Michigan. Were you in a motor vehicle?
Yes, sir.
Did you have a weapon?
Yes, sir.
What kind of weapon was it? Really? You want to get that?
Sorry. That was a 9 millimeter.
So you had a pistol. Was it loaded?
No, sir.
Where was it in the vehicle?
And I think located in the back seat.
In the back seat? Did you have any authority whatsoever to carry that firearm in that fashion?
No, sir.
All right. And you knew it was there in the vehicle?
Yes, sir.
All right. Sir, if I accept your plea, you understand that if you commit misconduct as defined by the Michigan court rules between the time of this plea and the time of your sentencing, that you, first of all, would not be entitled to withdraw your plea, and any evaluation or sentencing recommendation to the court no longer would be bound by. You understand that, sir?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or inducements that have led to this plea?
No, Your Honor. I am.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
So satisfied.
Defense is satisfied as well.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 District Court probation. Sentencing in this matter will be
September 4th at 10 a.m.
September 4th, 2025, 10 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. Oh, and I should also say 22 FB 1318 is also discussed.
Thank you very much, Judge.
We actually gave you the wrong sentencing date.
Hold on, that's the wrong sentencing date because that was Judge Washington's sentencing date.
I don't actually know.
It's Judge Washington.
Judge Barr on August 27th.
August 27th, 10 a.m.
Raise your hand if you've also stared at Zoom loading circles like they hold your fate. Same energy.
Thank you. Bond continue. Court does call the case of the people. I should also just finish that before I did that. Case FB 22 FB 1318 is also dismissed as part.
Thank you.
Court does call the case of the people versus Cartier-Reigns.
And for that was the people.
And Laura Yagi, Assistant Public Defender with and on behalf of Cartier-Reigns. Mr. James, can you unmute yourself and state your name for the court?
Also files for this block.
A wholesome moment in the middle of court chaos, because even justice pauses for a hey, sweetie.
APA Rachel McDuffie for the people on Mr. Harbin, Mr. Dushman.
Why are we calling Mr. Harbin? I didn't call that case. He did. He said something. Mr. Drains, can you state your name, please?
I, Cartier Armani Drains, hereby declare that I am a living, breathing human being, a natural person distinct from any legal or corporate entity or fiction. I do not consent to be represented or binded by any assumed legal identity or straw man. I assert my full rights under natural law and constitutional protection as a sovereign individual. I stand before this court to represent myself. All legal matters pertaining to the charges brought against me. I reject any notion or claim that my person may be divided, operated, or substituted by any separate legal entity. I affirm that all statements, evidence, and arguments I present are made on behalf of my living self, fully understanding my rights and responsibilities as a free individual.
Hey, you finished? All right, the court on its own motion is going to adjourn this because we're going to have an issue here. I have a feeling. I'm going to adjourn this probable cause hearing next week, August 7th, 2025. That's at 9 a.m. That is in person. He must be here so that I can hear him clearly in terms of what he wishes to say to me.
Yes.
Bond at this time will continue. Thank you.
I'll follow up with you. Thank you.
Court does call the case of the people versus Samuel Freeman.